One of the most agonizing ways of harassment is implicating innocent people in false cases. Hence, it is very important to be aware with information on human rights and remedies against any kind of exploitation. I am Snigdha Mohapatra, and in this video of mine, I am going to talk about one such remedy, that is remedies against false FIRs. False FIRs can cause a great deal of mental abuse and distress to innocent people and is considered as a form of cruelty. A false FIR is registered when a person deliberately gives wrong information to the police with an intention to deceive and falsely implicate someone. So the question arises that what remedies can he seek and where? One of the foremost ways to deal with FIRs is to file an application under Section 482 of CRPC for quashing a frivolous FIR. Under this section, High Court has been vested with the inherent power to pass any order which is necessary in order to prevent abuse of process of court or to secure ends of justice to the people. In So Mittal versus Government of Karnataka, the Supreme Court held that when grave miscarriage of justice would be committed if the trial is allowed to proceed, or where the accused would be harassed unnecessarily if the trial is allowed, or when prima facie it appears to the court that the trial would likely to be end in acquittal, then the inherent power of court under section 482 of the Code of Criminal Procedure can be invoked by the High Court either to prevent abuse of process of the court or otherwise to secure the ends of justice. The person can approach the High Court for getting the false FIRs quashed by filing an application under section 482 of CRPC on the following grounds. First, the acts or omission on the basis of which the FIR has been lodged does not constitute an offence. Second, the offence for which the FIR has been registered against the accused has never happened. Third, the FIR contains merely baseless allegations without any reasonable ground to prove an offence against the accused. In the case of Abba Sahib Home versus the state of Maharashtra, it was held that the power of the court to quash the FIR should be exercised sparingly and subject to the satisfaction of the condition precedents to exercise of such power. The doctrine of inherent power is the basic support to the exercise of such power. The court is invested with such power to do justice and to ensure that basic rule of law is not violated. In the provisions of Section 482 of the Code, power to quash is one of the powers where the court would be empowered to quash the FIR even in a criminal proceeding in furtherance thereto. Now, the guidelines by Supreme Court where the false FIR can be quashed under Section 482 of CRPC has been explained in the case of Sundar Babu and others versus State of Tamil Nadu. The guidelines as stated are: when the FIR lodged against the accused does not contain any prima facie evidence against the accused in respect of the offence with which it is charged, or where the allegation made in the FIR does not disclose any cognizable offence against the accused, when the allegations made in the FIR and the evidence collected by the police on the basis of such evidence does not disclose commission of any offence that constitutes a case against the accused, where the offence disclosed in the FIR is a non-cognizable offence. In such a case, the police cannot start the investigation without the order of the magistrate under Section 155, subsection 2 of CRPC. Where the allegations made in the FIR are unbelievable, absurd, and that there is no ground to initiate the proceedings against the person, where there is an express bar to initiate the legal proceedings in any act dealing with criminal matters, where the FIR has been lodged maliciously or proceedings are instituted wrongly in order to falsely implicate a person in a false case to satisfy his personal grudge. If any of these grounds or guidelines as stated in the case are satisfied, then the court is empowered to quash the FIR. Another step to fight such frivolous FIRs is approaching the High Court for quashing such FIR by filing a writ petition under Article 226 of the Constitution. If the High Court found that great injustice has been done to such a person, it can quash such FIR. In such a case, the High Court can issue writs of mandamus and prohibition. Writ of mandamus can be issued against a police officer who has lodged such a false FIR, directing him to perform his duty in a lawful manner. The writ of prohibition can be issued to the subordinate court which is conducting the trial of a person which is based on false FIR lodged against such accused in order to stop such criminal proceedings. In case a false FIR has been registered for non-bailable offences, the person is apprehending arrest, then the first and foremost step which the accused must take is to seek anticipatory bail from the Sessions Court or the High Court. It's high time to raise your voice against such harassment and torture faced by a person because of false FIR lodged against him by taking action against such person who has lodged the false FIR. Thus, in order to take action against such person, there is a need to make people aware of the law and procedure through which they can take such action.